Yeah, I'm here.
And go ahead.
All right, thanks. Yeah, well, all right, we'll just skip Rick. So let me welcome all of you to the panel presentation on the Small Business Reorganization Act of 2019, which appears to have some greater appeal in the middle of a COVID-19 pandemic. We have a distinguished group of panelists. I'm not seeing all of them there yet. We need Judge Furay to start her video there. I see her picture, but she's not yet popping up on my screen. Hopefully she'll get here soon. I could spend all of our allotted hour mentioning their qualifications, but let me just talk about them briefly. Robert Handler is going to wave at us. He's a practitioner who has devoted more than 25 years to insolvency matters, represented debtors, creditors, trustees, S&Es, purchasers, and all kinds of commercial insolvencies. But most importantly, for the purpose of our panel, Bob is one of the original Chapter 5 trustees appointed in the Northern District of Illinois. The absent Judge Catherine Furay is the Chief Bankruptcy Judge for the Western District of Wisconsin. She's been on the bench for the last 7 years. Her credentials include the National Conference of Bankruptcy Judges Board of Governors, President of the TMA, 3 committees of the American Bankruptcy Institute, and the co-chair of the Central States Bankruptcy Seminar Advisory Committee. In her spare time, she sits on the bench, holds hearings, tries cases, and writes brilliant opinions. Finally, we welcome Professor Robert Lawless, the Max L. Rowe Professor of Law at the University of Illinois College of Law, where he served as Associate Dean and specializes in bankruptcy, consumer finance, and business law. Professor Lawless has authored countless articles on bankruptcy, including Subchapter 5, and is a co-author for the most recent edition of Secured Transactions. Professor Lawless, will you kindly provide us a short history of the Small Business Reorganization Act and some of its key features?
Sure. So I'm going to stop the screen share, and I've got some slides here a little bit. This is my wand. I've got some graphs and figures and stuff, and I'll share the slides again. But you asked maybe to do a little bit of an overview, right? We all know the Small Business Reorganization Act got signed into law on August 23rd, 2019, with an effective date of February 19th, 2020. It creates this new subchapter 5 we've already referred to, with a more streamlined and easier process for small businesses and small business owners. Both the business and the owners are eligible for subchapter 5 if they have less than, as the figure currently stands, $7.5 million in debt, total debts, and we'll talk a little bit about that threshold. I thought the first thing I'd do is just talk a little bit about kind of the history of the small business bankruptcy provisions, and maybe it might be surprising, but I would put kind of the origin of where we're at back in the Chandler Act of 1938, which set up the reorganization structure under the Bankruptcy Act of 1898, right? We had Chapter 10, Roman numeral 10, for corporations, and was a reorganization vehicle for large companies. We had Chapter 11, which was a more flexible procedure to do a composition of unsecured debt, principally aimed at smaller businesses. And then we had a Chapter 12, which allowed non-corporate debtors to reorganize what we would today would call single asset real estate cases. And you know, there was a legal arbitrage between the different provisions, different chapters. That was a common complaint. There was complaints about satellite litigation prior to the proceedings really even getting underway. So in the 1978 Bankruptcy Reform Act, what do? We get a single Chapter 11, right? We have everything moved into a single chapter. This is viewed as a big innovation. Of course, then complaints are about a one-size-fits-all approach. There were complex procedures that were appropriate for more complex cases, and the complaint was that it was just creating cost in smaller cases. So kind of the next thing that happens, of course, right, we get the unification, we get the pushback. We saw changes in 1994. There was a small step toward a separate proceeding, probably the most immediate predecessor of where we're at today, with this election to eliminate a disclosure statement. Many of you will remember that the National Bankruptcy Review Commission, the commission that issued its report in 1997, had extensive small business recommendations, had a whole chapter on small business recommendations. There was an undercurrent of concern in that report that small business Chapter 11s not drag out to the abuse of creditors. And then in 2005, BAP-CIPA picked up on this theme with what I would call almost bizarrely punitive provisions directed at small businesses and imposed greater reporting requirements. There were expanded grounds for dismissal. Deadlines became non-waivable. At least in my opinion, the BAP-CIPA rules never worked for small businesses. And the immediate then forebear to where we're at is, of course, the American Bankruptcy Institute Commission on Chapter 11, which issued a report in 2011, took I would describe a fairly different tack from its predecessor, its 1990s predecessor. Right there we saw, again, a recommendation for a small business chapter. Their threshold was a $10 million debt limit. They had flexible reporting requirements, and at least based on my research, this is the first time I ever saw a serious proposal that we eliminate the absolute priority rule for small businesses. So, you know, I kind of wanted just to talk about this a little bit, right? We get the commission report in 2014, Congress being what it is. It takes 6 years kind of from the commission report to where we are today. I don't want to suggest that the commission report was adopted lock, stock, and barrel, but a lot of what you see, at least the intellectual contribution to the current legislation, came from that report. But I wanted to kind of talk about the history because the small business bankruptcy law has been a story of reform and pushback, right? Of separate proceedings and then unified proceedings, and now we're back at, and we're starting to have separate proceedings. It wouldn't surprise me we start seeing complaints. I've already seen one complaint from one quarter about SBRA creating separate proceedings. So history cycles, maybe it will again. We will see. So just briefly, I was asked to just kind of go over the highlights of subchapter 5, and I don't want to anticipate the discussion we're going to have, but it seemed useful to just at least go over the main features and remind ourselves of the main features of subchapter 5. Again, it applies to any business with $7.5 million or less in debt. That number will revert back to $2,725,625 on March 27th, 2021. The raised debt cap was part of the CARES Act. There's an automatic repealer, which we may talk about later. And I kind of wonder whether we're not going to kind of end up with a Chapter 12 situation. Right? Those of us that have been doing this for a while remember when Chapter 12 was adopted, it was a temporary measure. It kept, there was a sunset and it kept getting extended until it was finally enacted on a permanent basis. I kind of wonder whether we won't see the same thing with the $7.5 million debt cap. Subchapter 5 does not apply to corporate groups that aggregate over that debt cap. It doesn't apply to publicly traded companies. It doesn't apply to single asset real estate cases. It does apply to individuals who are under that debt cap as long as 50% of their debts arose from commercial or business activities. There are administrative changes in subchapter 5 to the administration of a bankruptcy case. There's no unsecured creditors committee. The debtor remains in possession, but there is a subchapter 5 trustee with oversight duties and a hybrid role. We're going to hear more about that from Bob. There's no U.S. trustee fee in a subchapter 5. There are also changes to the substantive rules around confirmation. A debtor has to file a plan within 90 days, although the court can extend that deadline due to circumstances beyond the debtor's control. There's no disclosure statement. There's no absolute priority rule. It's a pretty big change. There's a disposable income test now that substitutes for the absolute priority rule. And an individual filer can strip down a lien on a primary residence if the lien secures a loan that was used for a small business. So some fairly significant changes substantively in terms of confirmation rules. And then finally, just the changes on discharge. If the plan is consensual, discharge will happen at confirmation. If the plan is non-consensual under subchapter 5, the discharge won't happen until completion of the payments. So in addition to kind of setting up the panel and just giving that quick overview of what the substantive provisions were, I was also asked to talk a little bit about what's been happening with subchapter 5. So if I can do that, just a second.
That's why we put you in charge of the slides.
Yeah, I know you did, right? And there we are again. So
We're happy to have you do it.
Yes.
screen sharing has failed, I am told.
Yeah.
We're going to do this.
There it is. Okay. Yeah.
How about that?
Okay,
Can
we're
you
getting
see it
there.
now?
Keep going.
Yeah, but you can see that, right?
Yes. Yes.
All right, very good. The magic of Zoom. I only do this 3 times a week with my students. So, so I wanted to talk, I was asking kind of like what's happening with subchapter 5, but I thought to understand kind of the numbers I'm going to show you, you have to understand how chapter 11s get counted. So most of the chapter 11 statistics you see, well, first of all, they're wrong, most of what you see, because they're counting every affiliate of a large corporate debtor as a separate chapter 11. So you have one economic unit counted multiple times. So as a visual here are the 155 chapter 11s that got counted from the bankruptcy of Le Pan Quotidian. Right? So to get an accurate picture of what, actually the chapter 11 filing rate, you have to go through and back out the affiliates to understand, right, what the economic unit is and get comparisons that are comparable over time. Ed Flynn at the American Bankruptcy Institute has done that hard work. I like to say I am nothing if not a lazy man. Ed is not. So Ed did this work and he was very kind and shared his data with me. And just as an aside, this isn't actually subchapter 5. These are all chapter 11s. If you do an affiliate adjusted chapter 11 count, we're down about 14% on a year-over-year basis since the end of May, that's when Ed began his count. But then going back into the subchapter 5 statistics, so just thinking about a business coming into your office, how many of them are going to be eligible for subchapter 5? So if we back out the affiliates, right, and we look historically at cases that would have been eligible for subchapter 5, and this comes from a database of all chapter 11s. I inflation adjusted their debts and all like that. You end up with, over the 2014 to 2018 period, 56.5% of chapter 11s would have been SIBRA eligible. So what's actually been happening, right? These are historic data, right? How many of the past cases would have been eligible. As of September 3rd, again, this is from the American Bankruptcy Institute. Thank you to them for sharing. 814 filings. This does not include elections in already filed cases. These figures also back out some cases, especially one large group of cases that were clearly ineligible and appear to be a clerical error. So this is about 80% of eligible debtors making the election if we look back historically. So not all debtors, but most debtors who are eligible are making the election. And then in terms of when they are happening, there was this, right, when it initially got adopted, not surprisingly, there was a big number of SIBRA filings, of subchapter 5 filings. They died off, but since then it's been pretty consistent. You see spikes at the end of the month, but a fairly consistent flow of subchapter 5 cases. Where are they happening? So these are the top 20 districts. Middle District of Florida, we've seen the Northern District of Illinois. The next slide actually is a map for the whole country. So the bigger the circle, the more filings. You look at this, it's pretty much following population. For some reason or other, the Middle District of Florida has a lot of these cases. I don't have a good reason for that. Dan, I'm going to turn it back to you, but I'm going to answer one question you asked me, is whether these numbers were meeting drafters' expectations. And I don't really know, because I don't know what the drafters' expectations were. I saw one essay complaining the act was a failure because there wasn't this flood of cases. Maybe some people expected a slew of filings, but Chapter 11 has little to offer many small businesses, right? Many small businesses liquidate or go out of business without a Chapter 11. And who can say what the effect of the pandemic has been? So, these are the numbers. Judge for yourself whether that's a success or not. And I'll turn it back to you.
Well, thanks, Bob. That was a really good introduction. I really appreciate that. I mean, I think that we have a limited amount of experience, but it appears as if the statute is working. It's meeting the needs of the people who are taking advantage of it. I think there's some unique aspects of it that are particularly helpful during the pandemic, but we're not quite there yet in the program. Well, let's ask Bob Handler. He's a subchapter 5 trustee, and maybe he can tell us what his experiences are and share a few of those. What's happening on a day-to-day basis in some of these cases. Bob, can you help us out there?
I'll give them my best. Here in Illinois, in the Northern District, we have now 5 subchapter 5 trustees. The goal of the program, at least insofar as the Northern District of Illinois is concerned, is to bring in business people with restructuring experience to assist the debtors and their lawyers and some of the adverse creditors to see if we can get them all on the same page. This comes from the trustee handbook. Our goal is to facilitate the confirmation of a plan, a consensual plan with no cram down. We have a perverse incentive. We get paid, of course, for our time in putting these things together. But if a non-consensual plan, if there's a cram down feature to any class, we also become the plan administrators. We're the distribution agents. Nevertheless, at least among my colleagues here, we play a kind of a dual role. Given our restructuring experience, we know whether or not a business can make it, or if it can make it with changes in either the debtor's operations or how a creditor, secured or otherwise, is going to enforce its claim. So our job has been somewhat between being a coach for the debtor. Have you tried this? Have you tried that? Maybe you don't need all these operations. I have one case where we've got a bunch of laundromats throughout the area. Do you really need all of them? Some of them might make money, some might not. This is your opportunity to get rid of some of them. On the other hand, we're also playing the role of a referee. You can't do that. That's not feasible. It won't work. From a business standpoint, that's where I think our real impact is. There's also, I think, a fairly decent bright line between what we do and what the U.S. Trustee's Office does. The U.S. Trustee's Office is, very much on top of rules, procedures, deadlines, things of that sort. We come from the background of saying what's going to work, what's not going to work. If somebody misses a deadline or something like that, do we think it's material? From my standpoint, I'm looking at deadlines as being just a question point, a stopping point. Does this make a difference as to whether or not I can help get a consensual plan on file? That's the biggest difference, I think. And I think the U.S. Trustee's Office looks at us as their eyes and ears about what's going on the business side. So,
are you finding yourself at times supplanting the role of either the debtor's counsel or financial advisor?
Clearly, the financial advisor is, cases of this size, even with the $7.5 million threshold, none of my cases have had a financial advisor involved. Debtors counsel, for the most part, my dialogue with them has been very professional. They are looking to us for advice about what's going to work, what's not going to work. Many times they agree with our assessment, but they're having difficulty convincing their client about what the business reality is. And they're looking at us for guidance and perhaps help with getting their client to that next level about what's going to work, what's not going to work. That's generally the way it's been working. But we've also been, we've been the referee as well, saying, if you take it this far, if you're going to take this position with this plan, guess what? The judge is going to look at us at the confirmation hearing. Mr. Subchapter 5 trustee, do you support this plan? Is this plan feasible? We tell them right up front, look, we're going to say no, because the judge is looking to us from the business side. Is this plan feasible? And that's the card that we generally play but only after we've spent a long time with the debtor and the critical vendors, as it were.
Okay. How has been what's been your experience, trying to do this remotely, trying to interact with creditors? You probably, I don't know, can you do that on a Zoom basis where you get all the creditors together? That's kind of a unique function. I kind of like that. Do you have separate chat rooms with the debtor and the creditors to negotiate plan terms? How's that working out?
Well, for the most part, myself and I took an informal survey of my colleagues about many of these issues. Most of us have visited each one of the debtors in person, observing social distancing, wearing masks. Just from a restructuring standpoint, I always go to where the client's operations are located. I want to see the interaction between the client and the staff. Does the client really know what's going on? Are there things that are going on in the business that are really bringing the business down? And I want to get the owner's perspective on why things work and don't work. And I want the owner to show me where they think the problems are. So I at least have that one meeting. Almost everything else, though, has been by Zoom, by group conference call. That's just the reality of the situation. And actually, we do get a lot of stuff done over the phone.
All right. Well, a couple of things that are, I know that I look like I'm wearing a striped suit. It's just I can't close my blinds anymore. It's either that or, I'm getting fitted for a new prison outfit. But let me before we leave you, Bob, there's a couple of things that I think people are really interested. One, I know that when the statute was enacted, people were really concerned about how Chapter 5, Subchapter 5 trustees were going to be compensated. And can you speak to us a little bit about your experience? Is it too soon to ask you about that, or what's happening? I know that there's an ability for debtors to stretch out the payments. I know in some circumstances, I've seen a couple plans, Subchapter 5 plans, in which the creditors are paid with the trustee being called upon to prosecute the avoidance actions of the debtor, and perhaps separately compensated out of a fund created by the prosecution of avoidance actions. Can you share anything with us about your experiences in that regard, please?
I've been paid in one case so far. The other cases that I have right now are not ripe, although one's getting pretty ripe now. I'll be filing a petition in that. My colleagues have also been paid in their cases, also under different circumstances. The payment stream, yeah, we are treated under the code as an administrative expense, which can be paid over a 3 to 5 year period. The one case where I did get paid, I got my full fee paid up front. That was on the eve of dismissal of the case. The debtor ultimately settled with its lenders and went on their merry way. We're seeing, for example, one of my colleagues negotiated his fee and the payment terms when he saw that there was a lot of cash left over. There was enough cushion in there to get more paid up front. So there's certainly that room there too.
Okay, I appreciate your comments. Have you had any cases that have been converted yet?
To 7?
Yes.
No, they've all been on the cusp. A couple have been on the cusp of dismissal because, well, for example, the very first case that I had, it shouldn't have been filed as a sub 5 at all. The debtor's counsel admitted she should not have checked the box. It was already a liquidating company. It was a medical practice. The doctor, he himself was already in Chapter 7. They had not gotten permission from the trustee to even file the 11. That case was dismissed. We have had no conversions yet under our watch.
Okay, well, thank you, appreciate that.
We have had conversions into Subchapter 5 of existing, Chapter 11 cases.
Yeah, I think we're going to ask the judge a little bit about that, whether she has any experience. Bob, while we're there, have any of your cases been converted, or have there been some resistance?
Was this to me or the judge?
To you, Bob?
No, none.
None, okay. Well, then we'll now turn to Her Honor. We have lots of questions for you. But first, why don't you just generally share your experiences with these cases? How many have you had to deal with?
I currently have 12, I think.
Ooh.
And I've had one that, excluding those 12, got filed, some things got negotiated, and as a practical matter, it enabled the debtor to dismiss and sort of move on. I've had another where debtor filed, debtor was a restaurant, wanted and applied for a PPP loan. Of course, there was the standard position of the SBA that as long as they were in, and actually what it was not the corporate debtor, it was the primary shareholder who was in bankruptcy. But SBA refused to make a loan to the entity, which also owned the large commercial building in which the restaurant was located, because a primary shareholder was in bankruptcy.
Right.
In that instance, the individual asked to dismiss their case without prejudice, dismissed. Literally 2 days later, they got the PPP loan. And it was a month before the individual then refiled.
Refiled, yeah, okay.
So we've had a series of those. One of the earlier fights or questions that has come up, and it might be peculiar to my district, has to do with the terms and provisions of compensation for debtors' counsel and other professionals that might be retained. We have had a long history in this district and in the Eastern District of Wisconsin as well of permitting alternative compensation provisions, meaning that there's been a process where lawyers get paid every month. There might be a holdback, there might not be. And then every 120 days, they do their application. I've now had 2 cases where the United States trustee has objected to that provision, taking the position that first, the bankruptcy code is absolutely clear. It says 120 days, and 120 days means 120 days. They have acknowledged the cases starting with Knutson that say there can be arrangements where you can collect earlier, provided, it would be an undue hardship, and if there has to be disgorgement or recoupment, etc. But the U.S. trustee took the position that that exception only applied in major cases where there are millions of dollars a month of fees that are being incurred, because gosh, it's not fair in those cases for law firms and other professionals to finance the debtor.
Sure.
And I understand that this fight or this objection has come up in 1 or 2 other circuits. I overruled the objection because my view is, especially if we look at the accelerated timeline, if you're really going to say 120 days, we all know you file your application, then there's the objection period, etc. By the time, if we made lawyers wait to apply only every 120 days, it is possible that the case is virtually going to be over before the lawyer ever gets paid. And although the fees that are being incurred are not $1 million or $2 million a month, given at least in my district, the size of the firms that are doing these cases, it may put as much of a hardship on them as it might put in a large case where you're incurring $1 million of fees a month. So that's one of the first fights that we've had.
What else? I don't want to cut you off. If you see other issues, I have a number of questions that I'd like to ask the whole panel before we even get to our hypothetical.
Yeah, I mean, a number of the other sorts of things that I'm seeing do probably fit into the hypothetical. A couple of the things early on that have come up at the scheduling or pretrial conferences are questions about voting. Do you have to vote? Can a non-vote be characterized under some circumstance as consent? Timing for 1111B elections. And I think many judges are beginning to build some of those deadlines into their preliminary orders. But I think I've sort of taken enough time because I know we have a lot of other interesting things for the hypothetical and a lot of questions.
We do, but if you can stay on the voting issue for just a second, I think that's I know that for a long time, even in my own practice, I saw a lot of issues as to what really means, what does impairment really mean for purposes of a plan or confirmation. And I think we went through a period of time where almost anything really would be an impairment, even a full payment out if it's stretched out over a period of time. It's now obviously could become a critical issue, especially now we're voting in subchapter 5 by classes as opposed to individual creditors being able to block plan confirmation. So yes, the issue of a no vote, no votes at all in any class, would that be deemed a rejection? Would it be deemed an acceptance? I know that we've struggled with that issue a little bit. But one of the things that I think everybody would like to hear everyone's view on, it has to do with the cram down provision, and that is when a debtor has to devote their projected disposable income to the payment of their creditors over the next 3 to 5 years. Let's look at that for just a minute, can we? And can we say what is projected disposable income? How do you calculate it, and how do you determine? Is it 3? Is it 5? Is 4 the right number? I know you still have to meet a best interest of creditors test, but in most of these cases, there's really not much available on a liquidation for unsecured creditors. So how can we formulate a plan, and how would we know whether or not a plan would be confirmable, and how much do we have to devote? Anybody at all would like to jump in and talk about this for a second? I think it's really worth discussing.
No, because whatever I'm going to say is going to be wrong.
Well, start.
That's a great question. Like, it's got this standard. I mean, so I think a lot of people know, I do more consumer stuff, and that's the standard in chapter 13. And
right,
for an individual, it makes sense. Right, the individual is going to keep on going. Right, so
easy.
Life goes on, and they have income come in. And I think in 1191, right? I mean, they're trying to say net income. Right, I think that's what that idea is. And I don't want to preview the hypothetical too much, but I think part of the issue here is, with the modifications as well, right? With an individual, the life's going to go on, they're going to earn an income, they're going to have expenses, et cetera. With a business, you're trying to make projections out, that's going to go up and down, right? But the process seems to contemplate we're going to make that estimate. There's going to be some sort of payment to creditors. There's not very much guidance on how you do that.
Right, but why 3 as opposed to 4 or 5? Please, Judge, help me out.
Well, I was going to say, but don't you do that anyway? Put aside that it's a sub 5. If I have a plan and I'm looking at feasibility in a regular chapter 11, I'm getting projections. I'm getting here is the projected income stream over a period of time. And my view is that at least the evidence is going to be presented to me, I'm guessing, is going to be very similar to that. Here are the debtor's projections. Are they going to be able to afford to make the payments over whatever the term of the plan is that they say they're going to make? And that's no different even than a 13, because I got a 5-year plan and a 13, and now some of them are being stretched out to 80 or 84 months. Who knows how much the income of the debtor is going to be 6 months from now, or whether they're going to get laid off, or whether expenses are going to go up or down. You do the best you can, and the farther out you get from today, the more I understand it's just going to be an educated guess.
Well, here's some thoughts that some people might consider using from other cases, which is you create a reserve fund for replacement of equipment, or for additional hiring, or for expansion if your business gets bigger and you need more capital in your business. And then as your experience develops, you use the money as planned, or you pay it out to your creditors if you don't need it for that purpose. So if you need a new pizza oven and you think 2 years is the remaining useful life, but you stretch it to 3, then you can use some of that money that you put away to pay your creditors. I think I can get that. What I'm trying to figure out, I mean, I assume that if you look at best interest of creditors as being the cap, meaning you can't pay less than that, then if you just devote your disposable income to the payment of your creditors, and you reach the point where you've achieved your best interest of creditors, do you have to go further than that, assuming that it's maybe in year 4? Or maybe you don't get there to year 5, so you still have to devote it to the payment to your creditors.
So
Go ahead.
sorry.
I was going to share one more thought. Somebody suggested that the way to
What we
propose it.
What we generally try to look at are 2 things. One is the excess cash flow after overhead and expenses have been covered. But there also, like you said, there should be reserves in there. But we look at reserves for 2 reasons. One, for the capital improvements, for replacement of equipment, but also now in this environment for that rainy day when COVID may rear its head on some of these businesses and either restrict their ability to service or shut them down completely. So we want to see those reserves, and we counsel the debtors to make a very aggressive pitch to the unsecured creditors for those large reserves. And let's circulate some draft plans and see what the pushback is going to be. But at the same time, we are also looking for a fair and equitable payment stream to the secured and the unsecured creditors that's going to make them happy. Because we know in our minds, because it's hard to, I don't think anybody knows where the bottom is on certain assets, especially real estate. I'm seeing some reluctance on some real estate lenders to push the issue. And I think they're generally willing in their minds to take the payment stream.
It's a new case.
To take the payment stream and not risk having to liquidate the asset on their own.
Right. I think there's that. And of course, I think some authors have opined that in the present COVID pandemic, you have to make the 1111B elections a future claim is fully secured, hoping that the debtor will recover and rebound, that there really isn't much of a choice there. I was just going to make one more observation about plans that I had heard, and then perhaps we'll turn to our hypothetical. And that is suggestions have been made, and I think good ones, that your plan should contain 2 alternative paths. One, if it's accepted consensually and it's confirmed under 1129A, and the other is if it's not, what happens if in a cram down situation, how and propose it. But of course, you probably would face a number of other issues if you got if the treatment were so disparate, unfair discrimination or what have you. But some people, and more than one person that I've talked to about this, has suggested that the right way to do this is to have alternative provisions, but make it more attractive for creditors to accept the plan. So,
There are-
go ahead,
There are a
please.
number of courts, Dan, that are actually including that in their pretrial or preliminary orders, which suggest that you might want to incorporate additional provisions in the plan if confirmation becomes non-consensual.
Interesting.
One example is Judge Luban, and she has included a provision addressing that in her orders.
You're getting to my sources here. Yes, and a question, by the way, someone has proposed a question to Judge Furay and to Bob, whether or not has either of you come out against confirmation of an otherwise consensual plan? I don't know, maybe too early to answer that question.
It's kind of early. I have not been in a confirmation hearing yet. I have given debtors and their counsel fair warning, the shot across the bow, saying, I'm not going to support this. This is not feasible, strictly from a business standpoint. They may think it's going to be consensual, but I'm not agreeing to it because I just don't think it is feasible.
All right.
And I have not yet crossed that bridge, but I will say that I can imagine circumstances where even if it appears the plan is consensual, I might not confirm it. I mean, I don't think it's my job to raise issues or questions, but if there's something that I think is clearly a violation of the terms and provisions of the code, I don't think I can confirm that kind of a plan.
Sure.
And of course, that's no different than traditional Chapter 11 either.
Right.
All right. So now we're going to ask Professor Lawless to see if he can get the hypothetical that we drafted up on the screen.
On my way.
Thank you.
See if we can get there. There we go.
Here we go. All right. So all the puns are mine, but obviously we had this with the payroll protection plan in mind, and our debtor Penny Pincher owns and operates Pied Piper Pies, a business hard hit by the COVID pandemic, cannot achieve social distancing in her restaurant. She took a $1.5 million payroll protection plan loan out and used all the proceeds. She has a secured loan to Porching Pay Up Bank, secured by all of the business assets, which are worth much less than the bank loan at auction, which is typical in a restaurant case. She's personally guaranteed the bank loan. It's secured by a junior mortgage on her residence. She's gotten a notice of a UCC foreclosure sale of the collateral. She has unsecured trade debt of about $500,000. There's an additional loan, additional obligation for a real estate lease where the diner formerly operated, and $1.5 million on the PPP loan. Professor, could you go to the second page of the hypothetical? Scroll down.
Oh, went the wrong way.
Okay. Sorry, I couldn't fall. So Penny consults you about filing a subchapter 5 case. Our plan is as follows: no payments on secured debt until 90 days after the diner reopens, or February 1st of 2022. Once the payments to the bank are due, the debtor will make the regular non-monthly default payments and cure the arrearage over the next 3 to 5 years out of their disposable income. No distribution on the balance due on the payroll protection plan loan, and all other claimants receive a pie every month after the diner reopens. Krusty Kreme, the largest unsecured creditor, says it will never vote to accept the plan. It pays nothing, of course, but a pie. Penny says she's unconcerned that her plan is confirmable. Is she right? Who wants to go first? Bob, you can go first. What do you think of this plan?
Well, you got two Bobs. We're both going to punt.
Let's do Handler first.
Well, there's some
This
parts,
is like teaching law school class. Go ahead.
there's some parts of the plan that I like, and there's other parts of the plan I'm thinking, what planet are you on, and where's debtors' counsel on this?
Don't settle. Just go right for it.
I mean, why would anybody make the regular non-default monthly note payments to the senior secured creditor? Why isn't the debtor bifurcating the payments between the actual secured portion and putting the rest in the unwashed masses of the unsecured?
That's a good question. Right? Can she bifurcate that claim, that secured claim, into two components?
I don't see why not. That's how we've been working with debtors on many of their plans.
Of course, if she does that, what happens? Two things. Number one, the bank can make the 1111B election to treat itself as fully secured. And I think the treatment that she proposes would be looked favorably upon by the bank. So she'd probably get an accepting class there if that was her desire.
Fair enough.
Okay.
I do like her idea of pushing the effective date to after the diner reopens. We have counseled our debtors to do the very same thing. Even further, we're saying at the later of when COVID restrictions have lifted, or 60 days after that, when you've actually been able to get some wind in your sails and get going.
Right. Build up a little.
Build up a little cash, build up a reserve,
Sure.
and then start going. Again, it's going to be a little bit of a standoff between the debtor and the senior secured creditor. The senior secured creditor has to think, am I better off in a liquidation? We counsel our debtors to do that liquidation analysis and have it ready to go. And we're happy to review that with them and make sure we've got all the bases covered. My goal is still to get a consensual plan on file, get that confirmed, and I'm going to be the debtor's advocate if I'm on board with that plan.
Okay. Professor Lawless, why don't you tell us what you
Yeah,
think?
so I hadn't thought about the idea of delaying the effective date. I mean, surely there's some outside limit on how long you can delay an effective date. You couldn't say the effective date is, I don't know, just to pick something ridiculous, 10 years from now.
Well, you certainly have a feasibility issue that you'll run
Right.
into eventually when
Right.
you're unable, using your cash flow, to either make the payments or cure the arrearage.
Right, but I guess just suggesting there might be some outer limit on how, we don't know how long the pandemic's going to last. We don't know how long these restrictions, this sort of crisis is going to last. Yeah, you might, I don't know, feasibility strikes me as a concern. I could see, I could just see in our argument that it just is not fair and equitable to push out an effective date.
We used to call some of these plans illusory, at one point. But if there was an outside date by which payments had to start being made, would that give you a comfort level?
Absolutely. I think, I guess I'm just making the point. I think my students always like to ask me, where do I draw the line, right? And I always say right here. My point is, I think there's a line at some point that strategy. I think that's a great idea, but I think at some point there's going to be a limit to that strategy of just delaying the effective date indefinitely. One of the things that another thought that occurred to me, you have this zero payment subchapter 5, at least zero payments to the unsecureds here, right? So that was an issue that I saw and I wondered about whether subchapter 5 would allow that. And I was maybe fighting the hypothetical a little bit, because you'd have to show projections in a plan that would have at least pay the secured claim in the lease. And this goes back to something, Judge Furay, you were mentioning. I don't think this is quite the same as feasibility, because feasibility, you just have to decide whether the projections are above some floor. Right? Here, you've got to decide whether the projections hit the right number. So if I'm going to say I'm going to pay 0, then you have to be convinced that after paying the secured claim and the lease, there's nothing left.
Judge Furay, before you answer that, we've gotten 3 questions about whether or not Penny's case exceeds the statutory debt limit in subchapter 5. And so I'm going to ask you to address that issue. And there have been some cases, by the way, that we have observed, some of them in the materials, about how you go about determining the amount of the debt. Perhaps you could enlighten us.
I have had one case where, depending on how you calculated and brought in some contingent liability and the like, they exceeded the debt, but they exceeded the debt before the temporary increase in the debt limit under the CARES Act. So had they waited what turned out to be about 3.5 weeks to file, there'd have been no question they were eligible because they were below the temporarily increased debt limit. I took what might be the incorrect legal analysis and position, but was the correct, I think, practical solution, which is they could have dismissed, turned around and refiled, and they clearly would have been eligible. There might, that might have given rise to some other issues and fights, but I saw no point in not permitting them to proceed. So I made the practical decision in that instance.
If Penny's loan is forgivable, could she file now and then force a forgiveness of the loan, or would she have to wait?
Well, I mean, I think you're sort of jumping ahead for us on the PPP loans. Early on, there were a number of cases where loans were being denied because the debtors were in bankruptcy.
Right.
Now we have cases where the debtors got the loans, they've come into bankruptcy, and I do not know yet the position that the SBA will take with respect to loan forgiveness, but I do know in at least one of my cases, from the accounting and operating reports that have been filed, all of the PPP loans were expended for payroll, all of the associated taxes, etc., and a very small percentage was expended to make some utility payments.
So pretty much forgivable obligations.
Yeah.
Right?
I mean, other than the small amount, I think it was $10,000-$12,000 in utilities, and if I recall, it's like 60% of that. So there would have been virtually none of the loan that ultimately should have to be repaid, and the debtor has completed back by June, I think the 18th, the expenditure of all the funds in the appropriate categories, and it went ahead and applied for forgiveness before they actually filed for bankruptcy. And here we are in September, and there's been no decision about forgiveness.
One of the
And
things
so
our
I think that's going to come up as a plan issue.
Right. One of the things our panel discussed was the disparity from state to state, where there are moratoriums on mortgage foreclosure or evictions versus other states. And Judge Rowe was kind enough to share what was going on in Wisconsin, where there are no moratoriums in place anymore. And, isn't that putting some extra pressure, you would think, on debtors at this point to seek some relief under the bankruptcy law? Another question has come up and that we might look at. It had to do with the mortgage on Penny's home, which is clearly not a purchase money mortgage. It was given as additional collateral to secure the bank borrowing. And can that be included somehow in Penny's plan? Does she need a separate case? Does she need separate counsel with respect to that?
I don't see why she couldn't file personally under subchapter 5.
Oh, yeah, I think she might have to.
Yeah.
Assuming that she would meet the qualifications, meaning that 50% or more of the obligations related to business indebtedness.
Yeah, the question, there was a good question about whether she needs separate counsel. My instinct would be not. I think we didn't say she's the sole owner, but that I think was the idea that we had in our head, that she's the sole owner. So to the extent that something's not in the economic interest of the LLC, it's also not in her economic interest. So I think you could probably represent her as well as the LLC.
Of course, someone asked the question, Bob Handler, why would she propose a plan that paid the secured creditor in full? That could be a reason why she might otherwise want to do that and devote her disposable income to the payment of that creditor versus her trade debt.
Yeah, interestingly though, what Professor Bob just mentioned, I am co-trustee in a matter where the owner and the business are both in subchapter 5. The owner and the business have separate counsel, but everything's intertwined. I mean, the mortgage for the building is owned by her personally, so she is directly responsible on that note. The business gave an upstream guarantee on that mortgage loan, but in turn, the business has its own loan from the same lender, which she guaranteed. Nevertheless, they filed separately. They have separate counsel. And as it turns out, I am co-trustee with another member here in the Northern District. I am trustee for the owner. My colleague is trustee for the business, but we do everything together. I mean, we're just trying to, maximize the economies of scale here. So we are always having joint meetings, the two of us, with the borrower's counsel and the owner herself on a regular basis. So there you go.
Well, some clever bankruptcy lawyers might try to extend the automatic stay to the mortgage foreclosure as long as the payments were being made, would stay the foreclosure on your house. But that result might vary from jurisdiction to jurisdiction. What do you think of that, Judge Furay?
You're right. Yeah,
We don't ask the easy questions here.
yeah, no, I think that's one of those questions that could sort of go either way depending on the facts that get presented. And the real specifics about timing and dollar amounts and the like. I do want to sort of jump back for a second because we're seeing that we've only got about 2 minutes left. And I would say for everybody's benefit, going to the question of what's troubling judges and we're debating right now is how do we decide if a plan is consensual? And this goes back to the do we have to vote or not? And there is truly a debate about do we need to vote or is there a way around sending out ballots, number one. But number two, assume ballots do get sent out. What if there's inaction? What if a class doesn't return their ballots? And we all know that happens. And I would note that there are cases going both ways that people might want to think about. There's a Ninth Circuit BAP case, and I'm dating myself because I actually remember this case from 1989, which is the Bell Road investment case that says a failure to vote is not an acceptance. And then there's the Rudy Sweetwater case and the DBSD North America case from Delaware and from Southern District of New York that go the other way that say inaction by a class can constitute acceptance?
I think these will become hot button issues as we get deeper into the pandemic. And let me just spend a minute just to thank my panelists. I'm sorry that we're out of time, but I really appreciate everyone's participation, and I think the presentation was great. We'd have applause, but no one could hear you.
Yeah. And there was a note to remind people to switch links if they want to view the consumer panel.
Right, right. For those of you who would like to go to the consumer panel, which comes up next, you need to leave this room and go to the other room and then come back in for the ethics room. If you want to hear the next panel on healthcare, you don't need to do anything, just stay here. And with that,